For my friends who have asked me in comments and DMs if I could please cover this current trial that is happening with NASCAR and one of the Michael Jordan race teams, this video is for you. I'm doing this for you, even though I know very little about racing. It is like the one US sport I know nothing about. But it is interesting, and if it helps to get you like credence with the dude or the racing fan in your life so they'll shut up when we're watching Lively Baldoni videos, a win is a win. All right, so here's what's going on. So this was only filed last year. It's actually gone to trial pretty fast. It is currently in trial in Charlotte, North Carolina in federal court. The case was brought by 2311 Racing and Front Row Motorsports. 2311 Racing is Michael Jordan's team. 23, obviously. I think the 11 might be because of the Air Jordan 11, which is like the rare Air 30th anniversary one. I don't know, but it's very Michael Jordan coded, versus the National Association for Stock Car Auto Racing, better known as NASCAR, and the current head of it, Jim France. If you don't know, NASCAR has been owned and operated by the France family for a very long time, pretty much since it began, and it is a very lucrative business for them, which is the problem. So this complaint has a great introduction, super banger. And basically what they are saying is that unlike other professional sports where the players have unions or the players have owners who have organizational bargaining power, where they can bargain with the league as a unit, either as players or owners. In NASCAR, there is no such thing. And NASCAR bargains individually with each and every team, basically giving that team zero leverage in that negotiation. Because number one, it's just them, right? So they're the only ones. Number two, the NASCAR Cup Series is really the only Cup Series of any, that anybody would even want to be in. So they control the only real competitive events that matter. There was another league, I think it was called ARCA, that started up. They just bought them. So they bought the only other league, right? So there's no other competitive organization out there. And pardon me if I say like sports terms like league that don't apply in racing. I'm doing my best here. And I think what was really the tipping point was a couple things that have happened over the last couple of years. Number one is that NASCAR bought all of the rights to all the speedways. So they are the ones with the exclusive rights to the really big speedways, including Daytona and Talladega. And so in order to compete in a Cup Series event, which NASCAR controls, you have to go to a NASCAR race, a NASCAR speedway, and you have to do what NASCAR tells you, and you only get as much money as NASCAR is willing to give you, because that's the only way for the teams to make money. And as I understand it, what they're saying is the teams have to put all this money in on the front end, having no idea if they're going to get any of it back. Because you enter the race and you hope for the best, but there is absolutely no guaranteed money for the teams, even though NASCAR is making hundreds of millions, if not billions of dollars off of TV rights by selling the TV rights to the races. And then the other thing that sounds like it was the tipping point was NASCAR decided to up the ante by saying, oh, by the way, not only are we going to control all of that, we're now going to tell you who you're going to buy car parts from. You have to buy them from this entity that we have decided is the only entity that matters. I'm sure they have some kind of controlling interest in that entity. And oh, by the way, when you guys agree to be part of NASCAR, you have to sign non-competition agreements, so you couldn't compete in any other races even if you wanted to. And so there was this sort of event where literally they said at like 5 p.m. one night, I think, NASCAR sent out all new agreements to all the racing teams. Or like, you have an hour to sign that thing. sign it or you're out. They eventually ended up extending it to midnight, but they basically said, sign it or you're out. And the thing is egregious. It's horrible. It's one-sided. All the teams that signed it said that they entered into it under duress and they didn't have the time to talk to a lawyer and all this kind of stuff. But the only two teams who didn't sign it are 23XI Racing and Front Row Motorsports, and they're the ones who brought the case. So the procedural posture of this thing is all over the place, just quickly. So NASCAR and France filed motions to dismiss. They were denied. The plaintiffs sought from the very beginning a motion for an injunction to stop NASCAR from enforcing all of those really bad agreements. They got that injunction in the district court. It was appealed by NASCAR up to the Fourth Circuit, and the Fourth Circuit reversed it. So that was sort of a big loss for the plaintiffs. However, since then, they've done pretty well. Since then, NASCAR and France filed counterclaims back against them. Those counterclaims were dismissed. Well, they got summary judgment on those counterclaims, so there's no more counterclaims. Now it's still just the original case where it's 23XI and Front Row versus NASCAR in France. Summary judgment motions were filed by both the plaintiffs and the defendants. The defendant's summary judgment motion was denied, right? Meaning the case still goes to trial. And the plaintiff's summary judgment motion was granted in part, which means that it established some facts that now the jury doesn't have to look at because the judge decided that these things are true as a matter of law, which is pretty rare, but also pretty good for them because it established, now they don't have to try those parts. Those parts are just automatically true in front of the jury. And these are those parts saying like, we don't have to argue. There's no dispute over the fact that NASCAR has control over the premier stock car racing market. It just does. There's no need for us to put on evidence about whether it does or are they really going to argue they don't, right? And then they talk about, and then number two, which is there's no issue that they are the premier purchaser in the market. They are the ones controlling the market because they have all of the market power. And both of these points are critical to an antitrust claim where you're trying to prove that NASCAR has a monopoly and that monopoly is anti-competitive, right? So they got this granted. They got this summary judgment granted, but here's the good part. So in granting summary judgment in the racing team's favor, NASCAR was arguing like, oh no, these are still issues of fact and we need to have a jury decide. And the judge was like, that's funny because in your counterclaim that has since gone away, you actually said in your counterclaim that you are the premier, it says blah, 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 that you are the market for entry of cars into NASCAR Cup Series and any other. They basically said, dude, you admitted this in your own counterclaim, and we're going to hold you to that. So that was a really big win for the racing teams. So what is in trial now is the rest of it. It's establishing that there was a monopoly, and that it's establishing after that monopoly allowed NASCAR to engage in anti-competitive behavior in violation of the federal Sherman Act. Now, because it is in trial now, they haven't done all the jury instructions, but we do have the proposed verdict form, and that's helpful in understanding what the jury is going to be asked to decide. Oh, by the way, they did try to settle this thing. They had this guy, God, I can't remember his name now, but he used to be the general counsel for the NBA, and he represents like every sports league known to mankind. He couldn't get this thing settled either, so they did their best. But like, here's what the proposed verdict form looks like. Did the racing teams prove by preponderance of the evidence that NASCAR has a monopoly in this area? Yes or no? And then if they say yes, that it maintained its monopoly by engaging in anti-competitive conduct, which is controlling the market and not allowing anybody else to compete. That's what the jury has to decide. And then it goes on to, who controlled it and blah, 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 blah. And then how much were these stock car racing teams injured and how much were they injured by? Now, Denny Hamlin testified today. And apparently that was pretty fiery when he was getting cross-examined by NASCAR. And Denny Hamlin is one of the people who, I cannot remember when, there's been multiple attempts over the years to try to unionize the drivers in NASCAR. And the last time it was done, he was one of the people trying to get it done. So he's super pissed at NASCAR. And he got up there and testified today. And apparently the cross-examination, there was a lot of fireworks. So that's what's going on in this case. I'm happy to answer questions to the extent that I'm capable. I don't totally understand racing, but I do think I understand what's going on here. So there you have it.